good afternoon, everyone. I'm sharing my slides. Can you see it? Jennifer, can you confirm?
Yes, we can see it.
Okay, good. So good morning or good afternoon, everyone. My name is Leonardo de Terlizzi. I am a senior legal advisor at CISAC. I would like to thank IPK for the kind invitation. It is really a pleasure to be here with you today. And today I will be discussing the impact of the new technology, in particular generative AI, on visual arts and photography. I will start with a very quick presentation of the organization that I represent. CISAC is the International Confederation of Societies of Authors and Composers. We were founded in 1926. We have almost 100 years of age. We are a non-governmental, not-for-profit organization representing the network of author societies all around the world. We have at present 227 societies from 116 countries around the world. You can see in these maps our worldwide presence. And in general, we represent over 4 million creators from all kinds of repertoire: music, audiovisual, visual art, literature, etc. So let's move to the topic of my presentation, artificial intelligence and visual arts. So as my colleague have already said, the advent of new technologies, particularly generative AI, has had a profound impact on various creative sectors, including, of course, visual arts and photography. These technologies have opened up new avenues for creativity, but they also pose significant challenges, especially in terms of copyright and intellectual property. In particular, generative AI is a transformative technology that is trained on existing data and uses specific algorithms to achieve certain goals. It has numerous applications across various sectors and is increasingly utilized in creative and cultural industries. However, it also presents risks that could potentially harm authors' livelihoods if not properly managed. And visual arts are usually affected by generative AI. Actually, AI can produce new works from massive data sets, which often include images protected by copyright. To obtain these images, AI freely scrapes existing ones from the internet. And data scraping is very easy because images are often freely accessible online. Generative AI can then produce vast, very enormous quantities of images very quickly. To give you an idea, over the period of 2022-2023, the volume of AI-generated images surpassed the number of photographs created in the first 150 years of photography. This is a huge amount of images created by artificial intelligence. Of course, with proper regulation, AI can offer substantial benefits to the creative sector. Let's explore how. Well, artists can harness AI to finalize and process their artworks with greater efficiencies. For instance, AI tools can help in refining details, adjusting colors, and even suggesting creative alterations based on the artist's initial vision. This can streamline the process, allowing artists to focus more on their creative expression rather than technical adjustments. AI can also speed up the creative process. By automating repetitive tasks or generating preliminary design, AI enables artists to explore new ideas more quickly. In some cases, AI is used by collective management organizations to enhance their operation. It can improve the management of authors' data by organizing and analyzing large volumes of information with greater accuracy. This ensures that creators' rights and royalties are properly tracked and managed. AI also plays a role in verifying and maintaining accurate authorship identification. Actually, some societies are experimenting the use of AI to analyze metadata and compare works, ensuring that the correct authors receive credit for their creation. While AI offers benefits, it also presents several significant challenges for visual artists. One major concern is that it results in a lack of fair remuneration for visual artists. As AI-generated art becomes more prevalent, it can drive down the value of original artworks and reduce the financial rewards that artists receive for their creations. AI technology can create art quickly and cheaply, which might lead people to prefer these low-cost options. This could, of course, hurt traditional artists who spend more time and money on their work, reduce their income and market opportunities, and make harder for them to earn a living from their works. The use of AI by existing images to generate new works can also lead to copyright infringement, because when AI scrapes copyright material to create new content, it raises questions about the ownership of the resulting works and whether original creators are being appropriately credited or compensated. And finally, using AI in visual arts, as in all other creative sectors, raises strictly legal, ethical, and responsibility issues. To illustrate the impressive capacity of AI technology, let's look at a notable example, the next Rembrandt project. This project demonstrates how AI can be used to produce art by analyzing existing styles. For this project, artificial intelligence studied the works of Rembrandt to generate a new portrait that mirrors his unique style. Basically, by examining the techniques and the details of other Rembrandt's portraits, artificial intelligence created an image that appears as it could have been painted by the master himself. You can see the result in this slide. In this one, we see an image created by DALL-E, an AI model developed by OpenAI, based on the prompt, an oil painting by Matisse of a humanoid robot playing chess. This piece imagines Matisse's style applied to a futuristic subject and shows the ability of AI to emulate the techniques of renowned artists. Next, we have another example which demonstrates the capacity of AI, in this case with photography. This photography was also created by DALL-E from the prompt, a photo of a silhouette of a person in a color-lit desert at night. The resulting photography captures a dramatic and surreal scene, and again, it shows the ability of AI to produce imaginative photographies from simple textual descriptions. Now let's look at design. This image was also created by DALL-E and features an armchair shaped like an avocado. And let's turn now to illustration. So the image here, at the right side, titled Dragon Battle, was generated using stable diffusion with the prompt Dragon Battle with a Man at Night in the style of Greg Rutkowski. The original image is on the left side, and this example showcases again the ability of AI to emulate the distinctive style of a contemporary artist like Rutkowski in this case, producing dynamic and detailed illustration from specific text description. Now, all these examples illustrate the profound impact that AI can have across various fields: painting, photography, comic strips, and illustration, expanding creative possibilities and challenging our traditional notions of authorship and originality. Let's turn now to the legal implication of generative AI in the field of visual arts. So, as we have seen with the presentation of my colleagues previously, the typical process of a generative AI system involves two main stages: input and output. The input stage refers to the stage where AI platforms scrape and analyze a large amount of data, and the output is the creation of a new work based on this data. From a legal point of view, what are the rights involved in this process? Well, there is general consensus that the rights involved in training works by AI system are the reproduction right, and the adaptation right, meaning the right to create derivative works. However, there are type of exceptions available across the world which may allow, in some cases, scraping of copyright-protected works. These are, for instance, the exception that allow transitory copies for technological process, which exists in many countries. We are of the view at CISAC that the ingestion of data by AI should not be fall under the scope of this exception, but it is not clear 100% according to some case laws across the world. Then we have the TDM exceptions that have been discussed at large during the previous presentations. TDM exceptions are usually allowed for education, research, or scientific purposes. And finally, in common law countries such as the US or Canada, the use of protected works by generative AI can be permitted under the fair use or fair dealing doctrine. In these cases, it is left to the courts to assess the legality of any exception based on a number of criteria related to the use of the protected work and its impact on the market. We have mentioned the TDM exception, so let's go deeper into this exception because it plays a key role here. TDM can be defined as an automated process that extracts and analyzes data and text, which AI systems use for training. Often, this data includes copyright-protected works. In many countries, TDM exceptions are implemented in a way that do not allow rights holders to know when their works are being used and to authorize such use. This poses several issues for creators. First, their works are exploited commercially with no consent and no proper remuneration. TDM can lead to generative AI outputs which infringe copyright on pre-existing works. And also, via TDM, AI platforms can generate works much faster and at a lower cost than human beings can do, thus creating a competing market with detrimental impact on rights holders. In some cases, text and data mining exceptions come with opt-out mechanisms. This allows rights holders to reserve their rights and prevent their works from being used in text and data mining, provided that they follow certain criteria. For example, Article 4.3 of the DSM directive that have been mentioned many times today offers such an opt-out option. Article 4.3 basically states that the TDM exceptions applies only if rights holders haven't explicitly reserved their rights. In simple terms, curators can opt out the TDM exception by clearly indicating that they don't want their works to be used by AI, and this must be done through machine-readable means. However, this opt-out approach might not be ideal in the field of visual arts. The specific situation and needs of visual artists can make it difficult for them to effectively use these mechanisms. Let's see why. To reserve their rights effectively, visual creators have a few options. I have resumed them in three pillars, let's say. One way to protect works is by limiting access to web pages where the content is displayed. This approach can prevent unauthorized scraping, but may also limit the work's visibility. Another one is the use of specific standard files, such as robots text and AI text. This can be used to instruct web crawlers and AI systems not to access or use specific content. For instance, robot text is a standard used to control how search engines index a website. And similarly, AI text and TDM rep files can indicate that content should not be mined by artificial intelligence. The third option is use of metadata. Adding metadata to digital files can signal restrictions on their use. This method, however, requires that the metadata be recognized and respected by all AI systems and mining tools. Each of the three methods has its challenges, and for visual artists who often need wide online exposure, managing these reservations can be difficult in practice. Why is it so? Well, first, images often have no access restrictions. Many images are readily available online without any access controls, making it difficult for creators for visual creators to prevent unauthorized uses. Second, the tools available for managing server access, the file text, are often very basic and may not effectively block all forms of automated content scraping or TDM activities. And when it comes to metadata, metadata which indicate usage restrictions are often removed or altered by websites. And last but not least, visual creators are not the distributors of their works. This is very important. Visual creators cannot control where their works are displayed. And while they can apply opt-out measures, for instance, on their own websites, most of their works are shared by other entities, such as museums, cultural sites, or by the press, etc., by media. So these third parties often do not follow the opt-out instructions of visual creators. This makes the opt-out approach very challenging for visual artists in practice, because, as I said, they have very little control over how and where their works are distributed. So until now, we have discussed the legal issues concerning the input stage. In terms of the output, the big issue for the visual arts sector, as for the other creative sector, is the protectability of AI-generated content. The main questions are, is the content created by generative AI original? Or is there enough human intervention in its creation? And what are the criteria to establish whether the human intervention is sufficiently relevant in the whole creative process? So without entering into detail, into a detailed analysis, which will require much more time, we can say that there is a general consensus, which is reflected in case law, that purely AI-generated content should not be protected by copyright. I will very briefly present some significant US case laws that highlight how courts and the US Copyright Office are addressing the issue of the protectability of AI-generated content. These are cases which have been discussed very much, so I think everybody knows them. On the left side, we have the case involving Zarya of the Dawn, which is a comic book which incorporates AI-generated images with text and arrangement created by human beings. So in this case, the US Copyright Office granted copyright protection only for the human-created elements, specifically the text and the selection and arrangement of the images, but not for the AI-generated images themselves. So in this decision, the Copyright Office ruled that works that involve a mix of AI and human contributions can have the human-created elements protected, provided that the human involvement is significant and clearly disclosed, which is the case here. The second case involved a work titled A Recent Entrance to Paradise, which was created entirely by artificial intelligence with no human involvement. And the claimant argued that the AI system's work should be protected under copyright, with himself as the owner via the work for hire doctrine. But the US Copyright Office denied registration for this work, reinforcing the requirement that copyright protection needs human authorship. In the Surya's case, a photographer created a piece that you can see at the right side by combining his original photograph, left side, with a copy of the famous painting by Van Gogh, The Starry Night, and he claimed for copyright protection. So in this case, the US Copyright Office denied the application, ruling that the it was artificial intelligence rather than the photographer who made the critical decisions about how to arrange and combine the elements of the work. So all these cases reinforce the requirement that significant human creative input is essential for copyright protection, even for works that incorporate AI-generated elements. So we have been analyzing the potential of AI in the field of visual arts. Now let's discuss what is needed to address the challenges posed by generative AI to visual creators. So first, we believe that relying on industry self-regulation is not sufficient. We believe that legislative intervention is essential for establishing clear and enforceable standards. And any new laws or regulation should prioritize one element above all: transparency. They should require AI platforms to disclose their practices regarding the use of copyrighted material for training. And this transparency is crucial to ensure that creators understand how their works are being used and to maintain accountability. So the CISAC community has defined, similarly to what IFPI, SAA, and IFRO has done, as illustrated by my colleagues previously, the CISAC community has defined a few principles that decision makers should consider when regulating AI to make sure that AI systems are acting transparently, ethically, and in compliance with international copyright law. First, creators should be in a position to authorize and prohibit the exploitation of their works and being compensated for such uses. We believe also that exceptions for text and data mining, which do not provide for effective opt-out by rights holders, should be avoided because they will impede rights holders to authorize the use of their works and to be properly rewarded. Licensing is very important. Licensing should be enabled and supported. Licensing is the solution and not the problem. And licensing is the most efficient way to ensure legitimate exploitation of the works and to ensure a fair and sustainable ecosystem. Transparency obligation should apply. This is essential for us. Credit should be given when AI generates outputs by ingesting pre-existing works. Legal responsibility for artificial intelligence operators should be put in place to ensure compliance with transparency obligations. And lastly, we have to remind the principle that AI is only an instrument in the service of human creativity. As we explore potential remuneration models for visual creators whose works are ingested by generative AI systems, some options are on the table. For the input, we believe that the solutions available for creators are establishing traditional licensing, which is the preferred option for the CISAC community, or in alternative, establishing fair compensation mechanisms for the use of copyrighted material, similarly to what is done for with the private copying levy system. And for the output stage, as we know, AI systems can produce generated works infinitely faster and a lower cost that human creators can do. And in this sense, they create a competing market. So in this sense, one possible solution is to apply competition law to address these market dynamics. And additionally, an option to be considered is the application of the concept of paying public domain to manage AI-generated outputs. The paying public domain concept involves charging a fee for the use of AI-generated material, which typically lacks copyright protection and thus falls into the public domain. This fee, will be used to compensate the original creators whose works help training the artificial intelligence. So these solutions might ensure fair compensation for creators, could support the creative community and mitigate the detrimental economic impact of AI-generated content on rights holders. So I've prepared this slide about the EU AI Act, but we have discussed in detail about these regulations. I will not enter into details. I will just say that CISAC considers the approval of the EU AI Act as an important step forward. We welcome this approval, and specifically, we welcome the introduction of transparency obligations for providers of general purpose AI models, which are now required to draw up and make publicly available a sufficiently detailed summary of the content used for training. It will be very important to see how these provisions, this principle will be implemented in practice, and we are following closely the process of implementing in practice this principle. I would like to conclude my presentation with a brief update on Singapore, among the countries pertaining to the ASEAN. We have been closely monitoring recent developments in this country, in Singapore, because they are of particular interest to us, to our community. So Singapore has an exception for computational data analysis, which allows the use of copyrighted works for that data analysis without requiring permission from copyright holders, as long as the works are lawfully accessed. We know that recently Singapore has opened a public consultation on copyright exceptions. In light of these developments, CISAC will participate to the public consultations, and we would like to recommend that decision makers in Singapore consider narrowing the scope of these exceptions. We believe that aligning the regulation more closely with the recent changes in the EU legal framework could help better balance the interests of both creators and users. To close my presentation, I would like to share a quote from Pablo Picasso, similar to what Sarah did with her presentation. Picasso said that the artist is a receptacle for emotions that come from all over the place, from the sky, from the earth, from a scrap of paper, from a passing shape, from a spider's web. The essence of Picasso's sentence is clear. Artistic creation is a deeply personal journey shaped by the artist's emotions, sensations, and unique experiences. It is a profound interaction with the world that no machine can replicate. Thank you very much for your attention.